Hello friends, how are you? Today I am going to discuss an important topic concerning Prevention of Corruption Act. Friends, as we know that in Prevention of Corruption Act there are multiple ways for the implication of innocent public servant. He might be caught red-handed, there might be a demand, and apart from that there might be a case of misappropriation. Apart from that, unjust enrichment and disproportionate of assessed are the primary concern of the Prevention of Corruption Act. But concerning the trap case, there are multiple queries by the public servant. Common queries are: if the concerned complainant turns hostile, what will be the fate of our case? If the concerned corroborating evidences means independent evidences are not going to support the case of complainant, what will be the fate? And apart from that, if there are multiple accused, means A1, A2 and many more. In that scenario, if there is a demand by one public servant and acceptance by another public servant or private person, in that scenario, what will be the fate? And concerning demand, acceptance, recoveries, the common queries are that whether all the elements are required to exist on record for the prosecution and conviction of public servant or not. So to answer all the queries, it is not easy for me to impose my thought on you, because I am a lawyer, and being a lawyer, it is my duty to inter alia explain the position of law so that you could understand the concept and could do best concerning your case. Friends, believe on me and yourself. And apart from that, the prime belief is that an accused shall be deemed to be innocent unless proven guilty. Whenever the concerned ACB or CBI traps you, do not say to yourself that you are a culprit person, and no need to be in depression, because you are innocent unless proven guilty. So on that methodology, we will start the functioning to understand the conceptual perspective behind the trap cases concerning all the points which I had narrated you in the present topic at the inception. Friends, the case which I will discuss is based on a trap case in which there are two accused, Mr. A1 and Mr. A2. Mr. A1 was convicted and Mr. A2 was acquitted. Judgment is pronounced by Honorable Telangana High Court. Case title is B. Balakrishna versus State of Telangana, and judgment date is 29th of Jan 2025. Judgment is published at Live Law bearing appeal number 1162/2017. In the present case at hand, both the concerned persons are public servant, because usually in a trap case there is two person, one might be a public servant and another might be a private person, but in the present case both are public servant. The allegation is that in Indrama Adarsha Gram housing scheme, certain houses were sanctioned to the beneficiaries, and apart from that, certain benefits like cement, rice, money had been sanctioned by the concerned government so that the indigent persons could have the benefit appropriately. But the complaint is that the alleged benefits were not given to them, and due to this, the concerned complainant and other person inter alia communicated with department. They had come to know the alleged function had been assigned to Mr. A1 and Mr. A2. At the inception, they met with Mr. A1, who inter alia demanded amount of rupees 11,000 towards a bribe, as per allegation of the complainant in the report. The demand was made on 2nd of March 2007, and inter alia after negotiation, the final amount decided was 7,000. Friends, to be noted that in the case of trap concerning Prevention of Corruption Act, the demand is sine qua non. If demand is not proved, in that scenario, the prosecution fails. So this theoretical perspective is required to be conceptually cleared by us. Demand means a voluntarily demand, not a suggestive demand, because in multiple cases, I have observed that suggestion is given by concerned complainant to the concerned accused. Sir, I want to give money. What is your requirement further? Please tell me, sir, whether we can negotiate. Please reduce the amount, etc., etc. Always remember that your conduct must be reflected in the transcription. And apart from that, there must be a pendency of work, and there should be a strong motive on the part of accused to demand the bribe. If all these elements are not existing in that scenario, we could avail the benefit. And you must remember that in a recent judgment, Honorable Bombay High Court specified that even though the voice sampling test is against the accused, but transcription must reveal that there is a demand. If there is no demand in that scenario, the accused could not be prosecuted. So the same methodology would be applicable in the present case as well. Apart from that, the time of report is quite important, because if there is a delay and delay is not explained properly in that scenario, the case would fail, and you could sustain the set point from the FIR column number 8, in which there is an entry to be made why there is a delay in lodging of the FIR. Usually this column is filled with a specific term NA, or with a specific term not advisable, not required, and apart from that, sometimes it is left blank. So this is not a joke to play with the life and liberty of the innocent accused or public servant. The concerned prosecution agency must understand their duty at law. They have to verify why there is a delay, and if there is a delay and there is no satisfactory explanation in that scenario, as per guidelines of Honorable Supreme Court in Lalita Kumari versus State of UP, the judgment is pronounced on 12th of November 2013. They are required to hold the inquiry to find out the real cause. If the complaint is not genuine, it is appearing that it is afterthought, or there is some polishing version in that scenario, it could be rejected. So Honorable Supreme Court even advised to the concerned authority, do not be in anxiety while working on subject, but things are that they usually avoid to follow the guidelines of Honorable Supreme Court, and apart from that, the guidelines are that they are bound to avail the opportunity to the concerned accused to explain the side as per rule number 47 of CVC guidelines, but they are not concerned with the same as well. So I could say that if the authorities are not able to recognize our rights in that scenario, we must come forward so that we could put up our side in a very efficient manner. In the present case at hand, the consent matter was reported on 5th of March 2007. It means there is a delay of 3 days, and without verifying the details, on 6th of March 2007, the FIR was registered. In pre-trap, the consent complainant inter alia produce the currency notes. You got the point now? And currency notes are counted at first. And after that, the number of currency notes are noted down in a separate document that is called memorandum. And after that, the consent currency note are inter alia treated with phenolphthalein powder. In the rest of the India and Maharashtra zone, it is treated with anthracene powder. And after that, it is inter alia put in the consent pocket of complainant, and advice is given to him not to touch these notes. And if the demand is raised by the concerned public servant, you are advised to give the said money to him. And in the last, chemical reactions are shown with the help of a chemical that is termed as sodium carbonate. But remember that these chemicals are easily available in the market and even in the chemistry lab of the concerned school and colleges. And in the meanwhile, a document is prepared which is usually termed as first mediator's report. Okay, na? The memorandum is inter alia merged in that document, because memorandum contains the basic description of the concerned currency note, and the first mediator report contains each and everything. The concerned description of the concerned currency note, the method of applying the alleged chemical, the method of showing the result of chemical analysis, and apart from that, the search of the concerned complainant before putting the alleged currency note in his pocket. You got the point now? So first mediator report is usually termed as Sapada Purv Karwai in Maharashtra zone, and apart from that, it is basically a pre-trap proceeding in Rajasthan and Haryana zone. Okay, now you got the point. Now it is easier for us. After that, the team is entirely given direction to proceed towards the spot. In that case, it had been happened. The concerned complainant inter alia met with accused number 1. As per allegation, he went alone, not with any supporting witnesses. If the concerned complainant gone alone, in that scenario, we could conclude that there is no one who inter alia heard or inter alia seen the alleged communication and conversation occurred allegedly between the complainant and the accused. If there is no eyewitness to the incident, in that scenario, their testimony reveals no confidence in the case. In the present case, the same scenario occurred. Inter alia had gone inside the room of the concerned accused. Inter alia given the money. He came back, put a signal, and team had inter alia entered the house of concerned accused number 1, and he was caught red-handed. That is very important. After that, color test was performed, and on the basis of alleged conversation, it was concluded that he demanded and accepted the alleged bribe. Friends, when the said proceeding is done, it is termed as trap proceeding or fard baramadgi, and it is also termed as second mediator report. You got the point, and now it is easier for us. But the key point is that on the spot, as per rule number 47 of CBC guidelines, the spot explanation of the concerned accused is required to be taken, which is usually avoided by the concerned ACB or CBI or by the business. They entirely put the version that he got depressed, he was not in a position to explain. So the concerned accused is having a right of getting a fair investigation, which means if he is getting depression or if he is not in a position to explain the circumstances, in that scenario, it's a duty of the concerned IO, while taking the accused in custody, that you are having a right to consult an advocate of your own choice. If that option is not given to the concerned accused, he could have the benefit as per legal position. For this, specific provisions had been incorporated in CRPC, that is section 41D, and apart from that, in B and SS, the said provisions had been incorporated. So you could avail the said legal remedies as per law in near future if that options are not given to you while challenging the alleged arrest that is arbitrary or on the illegal grounds. So no proceedings can be conducted in an anxiety manner or in illegal way to prejudice the constitutional and statutory rights of the concerned accused. You must remember all these things. In the present case, the concerned accused was charge sheeted with accused number 2 because accused number 2 was found to be in conspiracy as per allegation of the concerned ACB, and that's why he was also prosecuted. Very great point to be noted is that the CBI or the vigilance or the concerned ACB sometimes, without verifying the facts, indulge certain persons who never demanded, who never accepted, but they are robbed in. So in that scenario, they may file discharge or questioning because demand is sine qua non, and apart from that, active collusion is required to be proved not by mere suggestions, mere averment, but there must be strong evidences on the record on the basis of which the court could draw the conclusion at prima facie level. If these elements, circumstances are absent in that scenario, the benefit could be availed by the innocent accused. In that case, the concerned complainant was hostile. Apart from that, there was not demand and acceptance by the concerned accused number 1. He strongly pleaded the said fact in the light of an important fact that there is no pendency of work. Pendency of work is one of the most important factor to germinate motive. If there is no motive, in that scenario, the concerned accused cannot be robbed in a false case under Prevention of Corruption Act. Apart from that, he submitted that there is nothing on the record to connect the accused with the alleged crime, and the same had been rebutted by the state. The state submitted that there is recovery, there is specific demand. He rightly convicted by the concerned trial court, and apart from that, even though the complainant turns hostile, the other witnesses, if supporting the case of the prosecution, in that scenario, the accused could be convicted, and he relied on important judgment of Honorable Supreme Court, that is State of Karnataka versus Chandra Shah. The judgment is pronounced on 26th of November 2024, in which it is specific that although demand is sine qua non, although the connecting evidence must be on record, but if the concerned accused is not able to explain the adverse evidences, in that scenario, the concerned court could convict the accused. In the present case, the concerned accused inter alia submitted the 5 major points lead to his acquittal. Point number 1. The concerned agency has not verified the point of pendency work. No work was pending with me, and inter alia, the concerned departmental witnesses had explained the said fact in toto. The concerned witnesses from department submitted that the house was sanctioned as per list, and inter alia, the file had been submitted to accused number 2. Through accused number 2, the file is submitted to district manager, housing, and inter alia it is forwarded to concerned collector. And after that, the work started. And in the meanwhile, the concerned A2 is bound to do inspection and to prepare the inspection report. And while doing the inspection, the measurement is required to be noted in the concerned M book. And after that, A1 is bound to issue bills so that the amount could be released in the accounts of concerned beneficiaries. So, in the present case at hand, it is admitted that no inspection report had been submitted with measurement to concerned A1, and that's why it was not possible to issue the concerned bill and to further reimburse the amount in the accounts of concerned beneficiary. The same was also corroborated by the prosecution witnesses. That is witness number 13. He submitted that there are two lists. The concerned complainant and the other beneficiaries were in list number 2. Until and unless the measurement and the inspection report is submitted, A1 was not bound to issue the bill and the concerned accountant was not bound to release the amount in the concerned accounts of beneficiaries. So, he specified that there is no pendency of work because the alleged inspection report and measurements were not submitted to him. So, these are important points, friends. You must remember that the preponderance of the probability is the prime concern which is required to be borne by you in your mind. Because the prosecution is bound to prove the case beyond doubt, but you are required to stand at the touchstone or at the formula of preponderance of the probability, which means you are required to create such suspicions, such scenarios on the record by the virtue of which the court could draw a presumption that, by the virtue of which the court could have a stand in your favor that you are innocent. But failure to adopt the said protocol may lead to presumption against you as per section 20 of PC Act, but remember that to draw the said presumption, even the concerned prosecution is bound to prove the case at prima facie level. If the elements are not existing, in that scenario you could not be convicted. And apart from that, in judgment of Neeraj Datta versus State of NCT, Honorable Supreme Court specified that all these elements are required to be proved beyond reasonable doubt until and unless the concerned prosecution has not taken any step to prove the same. In that scenario, accused could not be convicted on mere surmises and conjecture. So these are the important guidelines. Apart from that, he submitted that there is no specific demand because in absence of pendency of work, motive is absent. So we must remember the judgment of Honorable Jharkhand High Court, Parmod versus State of Jharkhand, judgment date is 16th of November 2022. In that case also, Honorable Court specified that the pendency of work is one of the most important criteria to generate motive. If there is no pendency of work, then we could have the benefit. Number 3, rule number 47 of CBC guidelines are quite important. Number 4, mere recovery, mere acceptance are not sufficient. The demand is required to be proved, but demand must be voluntary demand. And number 5th is that while conducting the proceedings, we must remember the basic formulas that the direct evidence is the best piece of evidence and the consent documentary evidence being the primary evidence are considered at priority as comparison to ocular evidence. And among the ocular evidence, the direct evidence must be available. If other witnesses are hearsay evidences, in that scenario, we could easily have the benefit because there is a possibility that the consent complainant would depose against you. And apart from that, you must remember that in the alleged transcription, if the theory of prosecution is not going to match with the consent report, then you can have the benefit. So we must consider all these points in a very efficient manner and in the legal manner so that we could prepare the notes and could contest our case. So these are the basic guidelines on which you have to work out to avail the remedy of acquittal. So see you in the next video. Till then, Jai Hind, Jai Bharat.